Okay, before we get into this more standard NDA, I need to remind you of two very important things. Number one, I have to say again that I'm not a lawyer, and if you're unsure about using this NDA template, have an attorney review it before you present it to anyone. Having said that, this is the actual NDA that I use for my company, so it's good enough for me, and that's why I'm sharing it with you. If you want to see other examples of NDAs, just Google NDA Template or NDA Builder, and you'll find plenty of those on the internet. And the second thing I want to remind you of is, don't get into business relationships with people you don't trust, because even the most well-written NDA can't stop bad people from doing bad things. Okay, so let's get into the language of this standard NDA. So first off, it says very clearly at the top that this is a one-way NDA, meaning one party, which will be you, will be disclosing confidential information to another party. The parties are whoever is involved with this agreement. The disclosing party is the one sharing the confidential information, and the receiving party is the one agreeing to not disclose the confidential information. So your name or your company's name goes in the first blank, and the receiving party's name goes in the one beneath it. The summary is basically stating what this agreement entails, and that the disclosing party, which is you, may disclose confidential or proprietary information during your conversation or meeting. And it's saying that both parties are agreeing to keep this confidential information secret. The next section goes on to define confidential information, saying that it includes all information or material that has commercial value to the disclosing party, which again is you. It also goes on to state that if the confidential information is in written form, the disclosing party shall label or stamp the materials with the word confidential or some similar warning. For example, anytime I send drawings of my products to a manufacturer, I make sure to label them confidential with a red stamp. If you don't have a stamp, you could just write the word confidential on whatever document you're sending. It goes on to say that if the confidential information is disclosed verbally, the disclosing party will give fair warning before presenting that information. If you forget to do that, this NDA says that you will promptly notify the receiving party in writing that the information you disclosed was confidential, and this could be a simple email reminder that summarizes your conversation or meeting. The exclusions section makes clear what the receiving party is not responsible for, and that is publicly known information, information that becomes publicly known, or information that the receiving party already knows or comes to know of through legitimate means. So if I tell a company that I have some sort of secret information, but in reality I'm mistaken and this information is already known to the public, then the receiving party is not obligated to keep that information confidential. This section basically protects receiving parties from any disclosing parties who incorrectly believe that their information is proprietary. The obligations are the responsibilities of the receiving party. It states that the receiving party must maintain strict confidentiality. That means they have a responsibility to put forth their best effort to protect your information. They also have to get approval in writing from you if they feel they need to share your information with another party. It also gives you the right to immediately reclaim any records, notes, or samples that you may have given to the receiving party. The time period section says that the agreement will remain in effect even after both parties decide to terminate their relationship. This clause is meant to protect the disclosing party. For example, if you decide to fire your prototype maker, this provision still obligates them to keep your confidential information secret. This provision prevents the receiving party from holding the disclosing party's information hostage. If you wanted, you could put a finite time period in this section, but I prefer leaving the time period indefinite. So here are some things to note in the miscellaneous section. It states that the NDA does not imply that you and the receiving party are in any way tied together in a partnership. Sometimes vendors will try to claim ownership of your idea because they made suggestions or edits to it. This language makes very clear that it's you, the disclosing party, that is the owner of the idea. It also says that any changes to this agreement need to be approved by both parties in writing. I recommend putting your home state in this blank here that's circled in red. unless you have some legal reason to want your NDA governed by the rules of another state. Next, there's some language about arbitration. Basically, it's saying that any disagreement shall be settled through arbitration and gives the winning party the right to collect attorney's fees from the losing party. Some people prefer to take this language about arbitration out, but I choose to leave it in my NDAs because arbitration is known to be a lot less expensive and a much faster process. Next, it makes clear that this agreement basically nullifies any previous agreements you had with the receiving party. And finally, it talks about how any representatives, assigns, or successors are also bound by this agreement. For example, let's say a business development manager at a prototype design company signs your NDA. That means any employees of the company who know about your idea are also bound to not disclose it to anyone. In the signature section, make sure to sign in the correct location. In a lot of cases, you'll send your unsigned NDA via email prior to beginning any sort of working relationship with the receiving party. If they agree to the terms of your NDA, they'll sign it and send you a scanned copy, which you can then sign, scan, and email back to them for their records. Make sure to keep your copy in a safe place. So that does it for this explanation on this more standard, formal NDA. Don't forget the most important thing, which is to never sign a contract with anyone you don't trust in the first place.